and advantaging the others, participants in market competition. Maybe one can say that there is, in fact, demand for tax neutrality behind this constitutional principle. Stimulating the economic progress and social welfare and caring for the economic development of all the regions, that's obviously the state's task put into the Croatian constitution. Referring again to discussion in the context of Josef's presentation, maybe the problem in this discussion between two of you, Josef and Marwan, is the problem well, let's say, my opinion would be maybe inaccurate wording of Israeli constitution, because general welfare, national security, as I see, is the part of general welfare. So perhaps there is no need to put both of them. One minor is already contained in a bigger one. But this one, economic progress and social welfare, it could lead to maybe always maybe, but maybe there are some conflicting objectives when it comes to taxation. Economic progress, for example, progress would ask, and in fact perhaps asks, for for a limiting taxation. The best tax is the more the tax. Let's cut the taxes would be the demand of the economic progress, and let's leave as much money as it is possible to entrepreneurs, and with the goal to so that they pursue the goal of broadening their economic activity and their businesses. On the other hand, social welfare would ask for more taxation, because the more tax revenue is collected, the more could be and can be spent from budget to finance social welfare. Then the rights acquired to the investment of capital shall not be diminished in any way. That's all a reaction, in fact, in Croatia. I'm speaking of Croatia, of a country in transition. That's a reaction on a previous socialist system, which failed. So the investment and the freedom of investment and capital is relatively high on the list of pursued goals of the present constitutional and generally legal system in Croatia. And then the fifth paragraph, the situation of foreign investors. They are specifically emphasized as the ones that should enjoy the free transfer and the repatriation of profits and the capital invested. And again, taxes could be efficient instrument for hindering foreign investments indirectly. So there is no need to forbid foreign investments directly. Enough is to bring about taxes that will do it, in fact, indirectly, by hindering free transfer of profits and repatriation of profits and the capital that has been invested. All those constitutional provisions, however, can be are of practical importance only through the actions of constitutional court. And there is something about Constitutional Court's role up until now. Constitutional Court in Croatia did solve quite a number of problems, but tax cases are not very often on its agenda. There are, in fact, two, and I should perhaps say only two important tax law cases up until now. One refers to real estate transfer tax, and the other on three taxes, but it should be noted of local importance: on idle agricultural land, on unused entrepreneurial real estate, and on undeveloped building land. There is some. I don't want to go into the details of those cases. Just some remarks, and as you can see, some Constitutional Court's reasons. When we talk about those real estate transfer tax, the problem was that Act on real estate transfer tax provided for 20% tax increase in the case that taxpayer, which in that time was the buyer of the real estate, did not report the taxable fact, the fact that real estate transfer took place. Constitutional Court, some certain person, Mr. Ilić, lodged a constitutional suit, and Constitutional Court found his reasons and that his suit justifiable. Based on reasons in that case were punitive taxation. So that 20% increase of tax that one should pay, that one ought to pay or have to pay if he missed the deadline for submitting information on taxable facts, in fact is punitive taxation. There is, of course, a part of the tax system are the fines for tax misdemeanors, but tax is not, and the court held that tax could not be the instrument of punishing in that case. So that 20% increase is in fact punitive taxation, and as such contrary to Constitution. And then for those three taxes of local importance, it should be noted, it should be said that all those three taxes, in fact, their primary goal was really punishing the owners of real estate that didn't bring their real estate to use. So that was the first goal of the taxes, definitely. And second goal was to contribute through those taxes to contribute to local budgets. Constitutional Court was lodged against those taxes too, and again, Constitutional Court held that there is punitive taxation, and just like in previous case, it is contrary to Constitution. Then unequal or discriminatory treatment, since the taxable fact, when it comes to taxing real estate, taxable fact is the ownership over those real estates, and not the fact that those real estates has been used or not been used, and especially in the way the legislator, in fact, current governing structure imagined how it could be done, how it should be done. So then taxes, those three taxes, were coercing owners to use their real estate in a certain way, which contradicts to constitutional principle of constitutional principle that ownership cannot be infringed or limited in any way except for the reasons of order public. The principle of legal certainty found the court was also infringed. Was also hurt because owners of the real estate couldn't conclude from those taxes what's the use they should bring to what's the use they should bring to their real estate to. It was unclear. So what's the behavior a legislator ask them to comply. At the end, last but not least, those taxes held the constitutional court contrary to Article 51, ability to pay in first place, because they were there wasn't connection between those taxes or burden those taxes imposed to taxpayers and their ability to pay. And court held that principle of equality was also injured through putting those taxpayers in the unequal position to other owners of other real estates. So those taxes were abolished, and they are not part of Croatian tax system anymore. That much for the role of constitutional court, and two well, really not much, but that's what we have got at this moment. Two cases. I have to say, generally, constitutional court, if I may say so, drag his feet when it comes to solving constitutional cases. And at the moment, its reputation, its position as one of the key players of key judicial institutions in Croatian legal order is seriously diminished by the accusations that Constitutional Court is in fact under strong influence of the currently ruling governing structure. But that's the problem for itself. Now another issue or part of my work: stabilization and association agreement. That's something specific for candidate countries trying to join, trying to gain full membership of the European Union. Those slides are pretty much stuffed with text, so I won't go through every line of that. Just generally, those agreements are international agreements concluded between EC countries and non-EU member states. Perhaps it would read non-member states of EU, but okay. Looking from the part of European Union, conclusion of those agreements is based on Article 310 EC Treaty. You can see here that provision. And one more remark of a generally legal nature. They were not mentioned from the beginning. They were not mentioned as pre-accession legal instrument. But as time went by, they turned out to be something like that. And today it is something like general legal knowledge that they really are pre-accession agreement. When Croatia concluded its agreement with European Union in 2001, they were not considered pre-accession legal instrument. But at the time, that agreement was in the force in 2005, when all member states ratified the agreement. Agreement was seen at that time as a pre-accession legal instrument. Now, just a brief insight into the conditions to be fulfilled by non-member state to join the European Union. It is important for Croatia in the first place, of course, but just as I say, brief info. Establishing the regional cooperation, dakle conditions to be fulfilled. Establishing the regional cooperation, then fulfilling the rest of the full EU membership conditions. And third, and in this moment, the most difficult for Croatia, the most difficult condition to fulfill, European Union's readiness for further enlargement, overcoming so-called EU's enlargement fatigue, stemming from enlargement or from, I don't know, 12 or 10 to 25 member countries. Something on agreement's aim when it comes to prohibition of fiscal discrimination. The main goal is, or maybe the only one goal, one could argue, is the elimination of discrimination of individuals as well as legal persons. There are few provisions following few provisions aiming at that goal. There is standstill clause in Article 33. I don't want to read it to you. You can see what it is about. But standstill clause, the name standstill clause speaks for itself. Then Article 34 with its two paragraphs. All this the least common denominator is to eliminate discrimination, especially when it comes to exchange of goods between Croatia and the common market within European Union. There are some other provisions in agreement. Article 111, 119, and with its two paragraphs. And just as a note, the principle of residence has been taken into account. We all know, I suppose, the importance of residence. So the nationality of individual or legal person in as much as we can talk about the nationality of legal persons, is not of paramount importance anymore, except for United States of USA. So the principle of residence has to be built into the SA agreement when it comes to fiscal provisions. There are some other provisions. All of them, those two, aiming at aiming at closing Croatia and Croatian market to the market of the European Union. That is one more argument that those agreements, stabilization and accession agreements, and association agreements, are in fact pre-accession agreements preparing candidate country for full membership. Then Stabilization and Association Agreement and EU law, legal status in Croatia. Those agreements are international agreements. That agreement, in fact, there is only one with Croatia, of course. That agreement is an international agreement, and that means that it is above internal Croatian law. So, by its legal force, it is stronger. Let's say, let me put it that way, stronger than our internal law and internal acts. Thus, conclusion is that it is directly applicable by applicable by Croatian courts. However, this rarely occurs, and this is understatement. I don't know for any case that some Croatian court applied that agreement. Although it is established case law by ECJ in Luxembourg, that as you can see in that other sentence, courts could have a jurisdiction in the matter. Applying international agreements that were concluded by member states. Some scholars in Croatia, I would colloquially call them turbo Euro optimists, are arguing, but their arguments have strength by all means, but there are only in this stage there are only theoretical arguments. That complete acquis is already applicable in Croatian legal system, because Croatia has to adopt acquis. We are in the process of adopting acquis communautaire. So there is no reason why not apply acquis even now before we officially joined the European Union. So their arguments are legally funded. They are okay, but they are not applicable in practice. As you can see, how courts are definitely not impressed. I think they just even don't know about their opinion or the issue. Now, conventions for avoidance of double taxation, there is no problem about it, because Croatia has concluded considerable number of those conventions, something about, not something, but I think 46 at the moment. They are all based on OECD model, and they are differentiated from OECD model only in details, but there are also international agreements with and has a supranational by their legal force they are above Croatian internal laws, except for constitution, of course. But there was no need to challenge some Croatian inner regulations, because there was no cases of contradiction between our double taxation conventions and internal regulations. And just a small appendix, not completely, I have to admit, fitting into the general topic of this workshop, but I would like to draw your attention on opinions of the Ministry of Finance. There is I suppose, and they in Ministry of Finance, in tax administration, they see it as a flexible instrument for changing and amending tax laws when it suits them, and by issuing that opinions, they are circumventing, well, you know, slow and complicated, sometimes complicated democratic procedure of changing and amending tax law. But there are, of course, shortcomings. Is this a new source of law? That's why it's in fact a question, not a question, because they are issued, they are publicly available, but they are not officially published because they are officially not source of law. Taxpayers have to to take them into consideration when designing their situation and examining tax aspects and tax consequences of their business undertakings. But what's the real legal status of those opinions? It is still unclear, although they are at least for a decade on the Croatian tax scene. There is no need, or almost there is no need to say that that status of those opinions jeopardizes the principle of legal certainty, and always imposes the question how to deal with them. I have to draw your attention on the fact that these are not rulings. What's the term? Advanced rulings known in some other tax systems, for example, Anglo-Saxon, I suppose, in the first place. So they do not have the quality of advanced rulings. There is no Croatian tax system still is not familiar with advanced ruling. In fact, advanced rulings are not present in Croatian tax system. That would be all. Thank you for your attention and patience. Thank you. And just one thing, thank you. I would like to thank organizers for giving me the opportunity to participate in this project, and especially Marko Gređi. So, thank you.